Hello and welcome to Adapting to Accessibility. My name is Angela Morse. I am the Assistant Director of Acquisitions for the University of Texas at Arlington Libraries, and I'm joined today by my colleagues Rivir Berry, who is the Assistant Attorney, and Amy Wilkes, who is our Electronic Information Resource Accessibility Specialist. Our agenda today will go over a few topics. We're going to talk about how different people use the terms accessibility, why accessibility is important, the library workflow prior to the Title II regulation being passed and how it is now, how the TAPREC process brought the three of us together and our working relationship, approaches to assessing vendor platforms for accessibility compliance, how to foster accountability for accessibility, and then exceptions for when things are not compliant.
Hi, everyone. So when I first started working closely with the library, I realized that while we were both saying accessibility, we were meaning two different things. So for the library, accessibility is used as it relates to equitable access to knowledge, such as the removal of financial, legal, and institutional barriers to information, like open access. And for electronic information resources accessibility, from here on out, we will say EIR or EIRA. Accessibility is used in relation to access for people with disabilities. Digital accessibility is the removal of design and technological barriers that prevent equal use by people with disabilities. So you may be wondering, why is accessibility important? Accessibility ensures that all individuals, regardless of ability, can access and benefit from digital resources. It's about inclusivity, equal opportunity, and removing barriers that prevent people with disabilities from fully participating in education and society. The mission of educational institutions to serve all students and foster an inclusive academic environment, regardless of individual ability, is the mission of libraries and higher education. Our library here at UTA's mission is to blaze a path forward in knowledge, inquiry, and creation, empowering students, faculty, and the community to enrich lives through innovative resources, transformative learning, and collaborative engagement. Accessibility is also the law. It is many laws. We have the Americans with Disabilities Act, or the ADA, which prohibits discrimination based on disability and applies to public institutions, including universities. We have Section 504 of the Rehabilitation Act, which ensures that individuals with disabilities have equal access to federally funded programs, including higher education. Section 508 of the Rehabilitation Act requires federal agencies and any institution receiving federal funding to make their electronic and information technology accessible to people with disabilities. And then Texas has specific laws. Texas Administrative Code, Chapter 213 and 206 mandates that state agencies, including higher education institutions, comply with accessibility standards for electronic and information resources. Each state may have their own laws they need to follow. Recently, the Department of Justice Title II ruling clarified that digital accessibility is a civil right under the ADA, requiring public institutions to conform to Web Content Accessibility Guidelines, also known as WCAG, 2.1 AA standards. Most institutions have until April 24th, 2026 to be in compliance. Some smaller institutions may have until April 24th, 2027. Not only is it the right thing to do, but there are business benefits of accessibility compliance. There's legal protection, so you're reducing the risk of lawsuits and noncompliance penalties. You have a cost savings because when you proactively build accessible resources, it's more cost effective than retrofitting your inaccessible systems. Reputation enhancement, demonstrating the commitment to accessibility. So if that product is accessible, then it's one of the first options that's usually listed when someone asks us what resource that we recommend. You have an improved user experience. Accessible design benefits all users, not just those with diagnosed disabilities. For example, captions help non-native speakers, mobile users, and those in noisy environments. You're also getting a wider audience reach. Accessible content can be used by more people, including those using assistive technologies.
So I am going to discuss our previous versus our current workflow for purchasing electronic resources in the library. The library previously acted very independently. There was little to no oversight of our purchasing and procurement process. All electronic resources now must be reviewed and approved by Amy's team in EIR before purchasing or renewing. Invoices previously were received and processed and sent to our procurement for payment. And now we must attach letters showing the EIR has approved the purchase with our invoices. Otherwise, they will not process them for payment. Accessibility was never really discussed with vendors or when considering purchases. It just was not a thought or consideration that went into it. With the WCAG 2.1 AA compliance, we now reference that in all our meetings with vendors, and it is a factor when considering new products to purchase and during the trial period. And I would recommend that everyone have these conversations with vendors during renewals or new purchases.
So how the TAPREC process brought us together. The TAPREC process, it stands for Technology Approval Process Request. It is required by all university departments for purchase, renewals, use, or prescription of electronic resources. So during this process, we perform the accessibility assessments that we'll kind of talk about later. Angela will submit the TAPREC to my department. I will review that request. I'll start the assessment with the vendor. Anytime I have a question, I would have to reach out to Angela. She would get me the vendor contacts. She may have to actually be the one to reach out to the vendor on my behalf. And so this led to a closer working relationship and collaboration because the library uses a lot of resources. Let's see, for products that are not accessible, Angela, River, and I collaborate on crafting the fundamental alteration argument if that's an exception that we are allowed to pursue. Once that exception has been approved by the president, I create that form and I send it out so that it gets signed by Angela and the dean of the libraries. So for EIR accessibility, approaches to assessment, I'm going to start by requesting the vendor's VPAT or ACR. A VPAT is a voluntary product accessibility template, and an ACR is an accessibility conformance report. It's kind of used interchangeably. We use a scorecard that Laura Hopkins here at UTA created. It lists out the WCAG criteria, and each criteria has a weighted score based on if that criteria is going to completely block access and the prevalence of disability that we know our population has. And we get this information from research and from SAR Center statistics. This scorecard provides a letter score from A to F and a risk grade based on the use, the cost, and the confidence in the vendor documentation. We do sometimes get VPATs that are vendor supplied and not third party. And while that's fine, third-party documentation is usually more reliable. Some vendors will have their own accessibility teams, especially if higher education or state agencies kind of their moneymaker. And so those teams usually provide accurate documentation. It's all going to depend on the contents of each individual VPAT and their method of testing. That is how we determine our confidence. Sometimes, even if I feel like I'm still kind of confident in the VPAT, if everything says that it's fully supported, I'm still going to go to that vendor's webpage or catalog, and I'm going to do a quick manual assessment to make sure that there's not any glaring discrepancies. Testing can include automatic testing, which is usually done through a browser-based tool that kind of checks over the code, and it provides me with quick results that I can then go back and look at closer with manual testing. Manual testing is where I use keyboard navigation, a screen reader, color contrast checking tools, and a code inspector to go through the resource. If there's a mobile application, then it's downloaded onto a mobile device, and we check it with the assistive technology for each device. Since my job is both compliance and usability based, I usually start with automatic checking to make sure that the WCAG success criteria are met, and then notate areas that may or may not be failing, but would increase usability if changes were made, and then I take that back to the vendor.
So there does need to be some accountability, not only from the vendors, but with libraries themselves. Um, Libraries have the responsibility to ask vendors about accessibility compliance when considering purchases. We need to ask publishers about accessibility of journals and articles published by our own faculty, and encourage faculty to publish in journals that are compliant over ones that are not. You can invite your accessibility person, if you have one at your campus, to vendor product demonstrations and trials, and include them in conversations with vendors regarding accessibility and improvements that need to be made. We use a ticketing system, the TabRec, so that I can track where it is in the process of review. And if a deadline is coming up for payment of an invoice, I can let Amy know that, hey, I need this to be made a priority because we have to pay this invoice next week or 2 weeks, whenever the deadline is. And so that really can help speed things along if certain things need to be urgently reviewed.
When working with vendors on accessibility issues, the goal is to approach the conversation as an ally while emphasizing the business, legal, and ethical reasons for compliance. We want to frame the conversation as collaborative, not confrontational. We want to emphasize that it is a shared responsibility and a long-term investment on both parts. Highlight that there's a legal commitment for the university, but that it also should align with the vendor goals. They should want to reduce their risk, expand their market reach, community goodwill, not lose their contracts. You want to provide the vendor with specifics of the issues. You want to set clear expectations. So compliance level, the remediation roadmap, if they have one, when they're going to be able to get you updated accessibility documentation like a VPAT or an ACR. You want to always keep those lines of communication open. Some vendors are going to be more receptive than others. If they don't remediate, then gently remind them of the possibility of loss of contracts, lawsuits, reputational damage. The outcomes and next steps, the vendor fixing the issue or any of the issues, what we call remediation, is the best case scenario. If the vendor refuses to remediate or keeps saying they're going to fix it, but they continue to make no effort to do so, you may have to find an alternative resource or involve legal and procurement to enforce the EIR accessibility warranty clause. Now I'm going to pause for a minute and let River kind of touch base on how one would enforce that warranty clause.
So EIR accessibility warranty clause is what we call it. If you have a similar clause in your contract, it may be titled something a little bit different. But basically, it is a contract provision that allows us to demand remediation because our vendors are representing to us that they are already meeting the compliance standards, or we have edited some that they have plans and will reach compliance by a certain date. So if we find out that they are not in compliance, we have the option to demand that remediation be done, and gently demand. And if they are unable or unwilling to do so, we are able to terminate the contract and get our money back and not owe anymore. However, in order to use this successfully, you have to be willing to stop using the resource. So it's not something to go into until you are sure that your institution is really willing to cut off access to this if remediation is not done.
Thanks, River. So outside of enforcing that warranty clause, the library is going to determine and plan for any accommodations for things that can't be remediated. If that resource must be used, where the university or library decides they have to use this and we cannot get the vendor to remediate. At this point, UTA requires an exception form to be signed and documented. Sometimes leadership assumes the risk. They'll plan the accommodations, we do the documentation, but this is a business risk that each individual business has to make. And you want to remember that you want to work together to resolve these issues with your vendor, because most of us want these partnerships to continue. We have found some vendors are more willing to work with us than others.
So now we're going to talk a little bit about what happens when we can't get that remediation, but we still need to use the software or other resource. But before we get into that, I am a lawyer, not your institution's lawyer, unless you are someone watching this from UTA. And the application of any of these exceptions is very fact specific and may change even for your institution from one year to the next. So nothing in here is legal advice. Talk with your own legal counsel about any questions you have regarding this. But in the updates to the Title II regulations that Amy mentioned earlier, which is subchapter 8 of chapter 28 of the Code of Federal Regulations, sections 35.200 to 2.205, the DOJ acknowledged that 100% compliance is going to be difficult and probably impossible, and provided us with a few potential exceptions. There is one section titled exceptions, section 35.201, that enumerates 5 exceptions, most of which are not going to be applicable to library services. But out of those 5, the most likely to apply is archived web content. However, even that is pretty limited. And then the most likely, or the one that we have found to be most applicable to our library content, has been fundamental alteration from section 35.204, which is entitled duties. And that allows non-compliance without incurring a violation of the regulations, where compliance would cause a fundamental alteration in the nature of the service, program, or activity, or result in undue financial and administrative burdens. And also, before we move on to talking about what's required and how likely they are to succeed, at least in our experience, I should say we are self-identifying and documenting what we believe these exceptions are. However, when it comes time to defend this, either because someone has had a difficulty accessing our services, or because the DOJ has decided to do an audit, regulators and courts may not agree with us. So where possible, we want to be compliant from the jump, because then there's not a question. So fundamental alteration. This is where we have seen most things in the library realm, at least, get their exception, and in a lot of other realms. So an alteration to a program, service, or activity is fundamental if it changes the essential nature of the program, service, or activity. And before you can tell whether something changes that essential nature, you have to identify what it is. So you can ask questions like, what functions are essential to the nature of this program? What can you not run this program, service, or activity without? And why are those essential? To make sure you're not just identifying something that is really nice to have, but not actually fundamental. And which of those functions that you identified for this program, service, or activity does the resource that is non-compliant support? And how does it support that? And is there another accessible resource that can perform that function? Because if you have something else you can just slide into that slot, not using the resource, a non-compliant resource, isn't going to be a fundamental alteration. Some examples of where we've run into this are databases like EBSCO and Gale, which a lot of those big databases and a lot of the smaller ones also are inaccessible. A lot of them are working on improving that. But as university libraries, our accreditors require us to be able to provide scholarly resources necessary for research and instruction in order to maintain our accreditation and issue degrees that have significant weight in the job market. And so here we've identified an essential function of that provision of scholarly resources to support our giving degrees, our giving accredited degrees. And a lot of these databases have proprietary access to those, or have proprietary control over the information in them. So we cannot fulfill that accreditation requirement without using several of these databases. And then we have also run into, this is a little outside of the library, but some softwares where, or some research project where a particular software and its usage in a certain sphere of everyday life is the actual goal of the research project, and that project can't be completed without using it, even though that software is completely inaccessible. However, it is important to remember that up to the point that compliance would cause that fundamental alteration, we have to make the changes that we can. So if there's some plugin that we can put in, or we can get access another way, or some other change that can happen, we have to make those changes to the program, or use additional or other softwares. And it's also important to note that that the determination for both fundamental alteration and undue burden, which we're going to talk about in a second, has to be in writing and signed by your chief executive or their designee. And you can decide what level that goes down to, though it should be at least a department or division head based on the regulations. So undue financial and administrative burdens are something where compliance would cause a significant difficulty or expense to get to. But that's in light of all resources available for funding and operation and operating is what that should say. The program, service, or activity. We have had some pushback with whether that should be the departmental budget or the wider institutional budget based on historical application of the undue burden exception in other contexts for the ADA. We really need to be reading it as all of the resources available to the institution as a whole, not what you would typically think of as being available for a particular program. This isn't division budgets. This is everything you could theoretically bring to bear. Talking about historical application of this exception in other contexts, it has not typically been a winner for universities and other large or medium to large, really, agencies. But because we have such a tight timeline from when the rule was originally passed to our full compliance date, with some of our bigger systems that are going to potentially take whole departments offline if we're switching to them, or that are going to take multiple years that really couldn't be done in the time that we had, even if we had used every second from April 2024 to April 2026. We are seeing a greater likelihood that this is applicable, but this should be a fallback position, not your go-to. And it should be done with great consideration, which all of these should, but this is so historically a shaky argument that I would have a very serious conversation about every instance you use this. Whereas some of your other exceptions, you might get a little more routine. And then the last exception, which may have some application in our library world, is archived web content, which is web content, which is has a circular definition, but is defined in the regulations. That was created before the date compliance is required of the public entity. So either April 24th, 2026 or April 24th, 2027, depending on the size of your agency or really the public entity, or reproducing the content of physical media to created before that date that is retained exclusively for the reference, research, or record keeping, and is not altered, updated, or updated after the date of archiving, and is organized and stored in a dedicated area clearly identified as being archived. And to make use of this exception, you have to have all four of those things, and not one of them can change. As soon as one of those qualities about a particular piece of content changes, it is out of archived web content and needs to be in compliance. For most of what we typically think of as archives, this isn't going to be applicable, but for some of your smaller more limited subject archives, it's possible that those are not being regularly updated. Or you may have a special collection that has been digitized that is specific to your university that this might apply to, as long as it is clearly labeled. And you can have an archive where additional pieces of content that are separate from what was already there are added after the compliance date. But that's risky, having those mixed files. So it's best to keep, even if you have them on the same page, 2 separate headings where one is everything that is archived web content and the other is all of the files that are not or we're unsure about. And please come to our Q&A session on Wednesday, October 15th from 1:30 to 2.